Hello. Am I audible to all of you? Just a second. Can anyone confirm that? You can unmute yourself now.
Yes, sir.
Okay, okay. So, is there anyone who is not comfortable in Hindi, or I should speak in English only? Because many students have requested for a mixed session. Is there anyone who is not comfortable in Hindi?
Sir, comfortable. No problem.
So I think we should start the session. There are many more participants, but let's start the session as it's already 9:05. Okay, and my screen is also visible.
Yes,
Yes,
sir.
sir.
Okay, so we will start with the this is the format of the legal notice. This is a there is no prescribed format of any legal notice that you will send to anyone for any cause. Generally, legal notices are sent for the civil purposes. Civil cases, not for criminal cases. Generally, it is sent only for Section 138 NI Act. That is a criminal case. That is the exception. But more or less, it is sent for only civil cases. Okay. Hope you all understand that. So this is the journal formatting of any of the legal notice. Like if you will send the legal notice tomorrow when you will be uh, enrolled as an advocate, then your format should be like this. As your name, like here it is written as Manik Goyal, Advocate, Supreme Court of India, and then here it will be your office address. Okay, here it will be your office address, and then you can write your mobile number so that it will be easy for the other party or the other lawyer to contact you easily. Okay, and then your email ID. This is must. These all the things that I have written here are must. Like you can skip this part, that you can write here any other code. Like if you are practicing in any other court of the India, like you are practicing in High Court of Delhi, High Court of Karnataka, High Court of Madras, and any of the high courts, then you can write down there. And if you're practicing any district court, then you can write that too. But it is generally seen that all the people who are sending a legal notice, they generally use this terminology only, like Supreme Court of India or any of the high courts in India. They generally don't prefer to write that we are belonging to any district court of India, because that make a very less impact on the other party, the whom we are sending the legal notice. We are sending the legal notice on behalf of our client. Okay, and it should be impactful, first thing, because we want that our main purpose is that we will settle this issue at the very first legal notice of the case. Because in any civil case, there most of the civil cases you have to send a legal notice, like whether it's a recovery for any cause, whether it's any issue between the employer and employer, and any other purposes, any type of civil cases, more or less you have to send them a legal notice, so that you can give them a prior intimation that we are initiating a case be against you if you are not replying within a stipulated time, and you are not uh, giving us what we want legally. You can't say like if we have given someone 2 lakhs, you can't say that I want 10 lakhs until and unless you are proving that thing, that I have given that person 2 lakhs, but that person have mentally harassed me. He has not given my payment timely. I have suffered a lot for due to that. Then you can claim any other amount. Like you can ask the court that 2 lakh is my principal amount, and after that, uh, please try not to scribble on the screen. Like I can see, Chirag, can you stop that? Your pen is like okay. So this is the thing that you can send a legal notice to the other party. You have to be legally correct, that if you are demanding something, then you should be legally correct. So I think we should skip on the next part. So this is the thing. This is the journal part. Like you have to write here date. This is journal formatting, like a register AD, speed post, WhatsApp, email. This is journal part. You can copy this from my legal notice. I will share the formatting with you also. You can just add your name if you are an advocate, and if you are not an advocate right now, then you need not to have that formatting with you right now. When you will be lawyer, then you can use this formatting. You can like change the email ID, phone number, office address, and all the other things you can do at your end. Then after that, we are skipping to the main part, that whom we have to send the legal notice to the other party. So like I have written that to the director, managing director, Tech India Advocate Private Limited. This is the address of the other party to whom we are sending the legal notice. And then you can do this thing also, that you can CC this also, or you can skip that part also. It's not necessary. I have written it because my client have demanded that, sir, you should write this thing and you should send this legal notice to the co-founder and the CBO of the company also. Okay. So this is the general part. Is there anything like, if anyone has any question or something like that, then you can unmute yourself and ask me uh, right now.
Sir, what is registered AD?
Registered acknowledgement due. This is for the speed post purposes. A registered post is used before September 1st. It is not used right now because this is a old, as you can check that it is old. Right now, registered post is not available with any of the India Post services. Earlier, we used to send the legal notices via registered post only, because it is a like convention, or like it is like more or less like a convention between the advocates, that you have to send a legal notice via a registered post. You can send that via speed post also, by WhatsApp also, by email also. There is no issue with the credibility of the legal notice. But
So we should mention it in legal notice.
which thing you should mention?
Speed post, WhatsApp, email, through
Yeah,
which
you can. This is general formatting. You can skip this thing, registered AD. Okay. Other than, you can write that speed post slash WhatsApp slash email. You can do that. This is general formatting. Okay. And
okay, sir.
okay. So there is no bar. You can send the legal notice by speed post also, by WhatsApp also, by email also, and by any of the private couriers also, like DTDC, Blue Dart, or any of the couriers you wish to. But try to send it by India Post only, because you can track it properly. It gives you a proof also, all the things. Because generally in a registered post, when we used to send the registered post before 1st of September, when, because as of now, government of India has discontinued these services from the India Post. There is no registered post right now. So you can send it by the speed post, you can do a email to the other party, you can WhatsApp to the other party. But keep in mind that you should track that if because in usually in speed post, you have the tracking receipt that this particular legal notice has been delivered to the other party. So it becomes easy for you to give the that thing in writing to the court, that, sir, this particular legal notice has been delivered to the other party. So the delivery has been done from our side. So you can, because in section 138 of NIA Act, Negotiable Instruments Act, there is a time period, proper time period of 15 days, that you have to send this legal notice within a period of 15 days or 30 days. Okay. So you have to show that to the court, that I have sent this legal notice in a particular period. So it's best for you to send it via legal via this thing. Because on WhatsApp, if the other party has not opened their receipts, then it will not be possible for you to prove that in the court, that, sir, the other party have seen this particular legal notice. Because there is no such thing that you can prove that other party have seen that WhatsApp if their read receipt is not on. They have off their read receipts. Okay. And the same thing goes with the email also, because there is nothing you can track like that, that this email has been uh, read by the other party. Okay.
Sir,
So
sir,
yeah.
only advocate can send the notice, or any common person or party himself also can send the notice?
Usually the legal backing is of that only, that a lawyer will send that. Generally, anyone used to send that. Okay. But that has no backing in the court. Okay. If you are a lawyer, generally, if you are a lawyer, then you can send the legal notice. Like, anyone can't send the legal notice. Okay.
Aggrieved party also cannot send.
No. Aggrieved party can't send, like you can have a unofficial communication with the other party. That's you can send a unofficial letter, but that will not be counted a legal notice because you have not you don't have any authority, no, to send the legal notice. That will be counted as an normal communication from your side to the other party, to the defendant party, to the accused party, that I am sending you this unofficial or official communication. That will be an official communication only. That will not be counted a legal notice in any situation. And if you are sending it as a legal notice, then the other party will not bother to respond you also, because until and unless there is a legal complication involved in that case, the other party will not bother you to like even uh, reply you for that legal notice. So I think we should skip this as of now. I will take the questions at the end. So after that, you should mention this thing also. Subject of the, like here in my case, it is legal notice for the violation of the Maternity Benefit Act 1961. Hope you, most of you will be knowing this act that gives protection to the employees, okay, to women who are into the organizations, and they are given maternity benefits by the company. They are given a 6 months leave by the company, paid leave by the company, that and some other facilities also that is enshrined in the uh, very act of like this act, Maternity Benefit Act 1961. So you can read that, you can read that act, that is small act. So this act was for the payment because they have violated the terms of the Maternity Benefit Act. Generally this legal notice that I am showing you is between an employer and employee. Our client was an employee who was hired by this company since 2 years, and my client got pregnant and have applied for a paid leave, and they have given that, they have sanctioned that leave. The leave was for 180 days, that is within the constitution of that act, okay, and they have to pay the amount monthly, the like the salary monthly, but they were violating the provisions of that act by they were not giving the uh, salary timely. They were skipping the salary and they were arguing that our company is in financial crunch, we can't pay you the money and something like that. I am giving you the broad summary of this case, broad facts of this case. So this was the fact that our client was in like, due to pregnancy, she was suffering a lot, so she was in need of funds, okay. So that's why she asked us to send a legal notice to the other company for demanding the money, the dues from the other company, okay. So after that we have written like, dear recipient, you can uh, add here dear sir, dear ma'am, or you can add the name of, if there is only one person, then you can add the name also, dear Ram, Sham, and any other name, okay. And then there is a standard line which you have to write here: under instructions from and on behalf of my client, okay, Mrs. Vishali Sharma, that is the name of my client, okay. You can write it here, the name of your client, herein referred to as my client, because after that we will not use our client's name again and again, we will use my client, okay. And after that I am issuing this legal notice uh, to you for the violations and unfair treatment by this particular company, the name of the company, the Techniva Edutech Private Limited, herein referred to as the company, because we will not use the name of the company again and again, so we are using the name as the company, and it is management against my client. So this is the journal line. You just have to copy and paste this line. Sorry. So you have to just add your client's name and the other party's name to whom you are sending that legal notice, okay. And after that, legal notices are generally so easy that you have to write only facts. Like I have started with that, my client was employed by your company by appointment letter dated this September 23, 2022, because our client was hired in 2022. So you have to give a context to this case, that my client has been hired on which position, and as I have said that at manager sales and business development. So then you have to write that my client has worked hard or something like that. That depends on case to case. Like, I'm not saying that you will go through only this employer employee relationship legal notice. You can be hired for like recovery of money cases, okay, and other cases also. I will give you a brief also, that how we can draft this legal notice by AI also. That's the main purpose of this session, because generally we have seen, I will show you a legal notice also, that if you will read that legal notice, you will get to know that how people are drafting legal notice also. Wait, just wait a second. In the meanwhile, if you have any doubt, you can just unmute yourself. I am showing you one more legal notice right now.
Sir, what is the meaning of CC?
Like we use in the email also, no, carbon copy. That the same copy is being sent to the other party also. Okay.
Okay, sir.
Do you know CC in that email? If you will go to the email, you will send the email to the other party. It will show two. Then there is two more options, CC and BCC. Just wait a second.
Sir, I have one question.
Sure, please go on.
Sir, as you have said that there is no airtight rule regarding the format of legal writing. So are we supposed to write only in this format when we are writing legal notice under section 138 of NI Act, or if we have any other format we can follow that?
Yeah, you can follow any of the format. There for 138 also there is no prescribed format. Okay, this is a general formatting. You can change your name, you can change the fonts, you can skip your name here and there, you can do everything. I will show you a legal notice. Right, just wait a second.
Sir, I have a question.
Yeah, please ask.
For the internship that we are a part of, or even in the future, like if we are not registered as an advocate under any court, then in the starting, shall we only write our name and let it be, or we're supposed to write something else as well?
Like what are you saying? Like if you are not registered as an advocate?
Yeah, so like in the first page, like you mentioned how you have to write your name and then
Yeah.
below it. So if we are not an advocate, then what are we supposed to do?
Then you can't send that.
So are we supposed to write anything else in place of that, or we just skip that?
Like if you are not an advocate, then you can't send a legal notice to any of the parties. Okay. If you are
Okay.
an advocate, then only you can send that.
Okay, understood.
Okay. And if
Thank
you
you,
will,
sir.
and if you will send the legal notice, there might be some complication that you have to face that.
Okay.
Because that will be counted, that will not be counted as a legal notice. That will be counted as only a communication from a person, because you are not any legal like you don't have any legal uh, degree with you. Like you are not an enrolled advocate and with any bar council of the India, like state, any of the BCD and other. Okay, so you can't do
Okay, sir. Thank you.
Sir, I have a question.
Yeah.
Sir, as the question asked by Arya, the my one is also similar to that. As we are interning under NyayaSarthak, so we are supposed to send 4 or 5 of our drafting. So in that first page of, for instance, we are drafting a legal notice as our first task. So what should be the first page of us being a non-lawyers?
Yeah, that is only a task. You are not sending to any party. You are sending just to us for your internship.
Yeah.
So for that purpose, you can write as an advocate, like your name is Nancy Daya. You can
Yes, sir.
write it as Nancy Daya, Advocate, Supreme Court of India, because we are not going to
Okay.
share that with anyone. But if you are threatening with your name to any other party, like I am, like you are in your first year, okay,
Mhm.
and you are sending a legal notice to the other party that I am an advocate, enrolled advocate at the Supreme Court of India, okay, then that might create a issue with you.
Perfect. Thank you, sir.
Okay. And if you are having any complication, or if you are fearing that anyone can do anything, then you can just skip that. You can just mention Nancy Daya. Instead of advocate, you can just mention legal intern, Supreme Court of India.
All right, sir. Thank you.
Okay. So can you see this legal notice?
Yes, sir.
So this is a legal notice that is being sent by a advocate of a high court to the another party. So if you will read this legal notice, there is no formatting in this legal notice. If you will check this legal notice, there is no formatting. This is so vague legal notice that 90% of the lawyers in India are using this format only. That's why there is no, if we say कि इसका कोई सामने वाली पार्टी के ऊपर प्रभाव नहीं पड़ता, that the other party is not does not fear from this thing. Okay, it is written like to, as I have told you that you have to write to whom you are sending this legal notice. Then it is written, sir, I am sending this legal notice. There is no instruction that I am sending. I am sending this. There is no subject also. I am sending this legal notice to you under the instruction made by my client. This is the name, which is as follows. I will not go into these things. Like if you will check that there is a mistake in which also. That is not a big mistake, but it will make an impact on the other party. They will get to know that you are standing on nothing. Like you have no legal backing, you have no legal knowledge, you have no legal experience. It will show your experience to the other party, that how much experienced you are. And as I can check, there is a AOR code written also. As you are aware, AOR is advocate on record in the Supreme Court of India. But I don't think so that this legal notice is like sent by any AOR. But the code of AOR is written on the top of the legal notice, AOR code. Okay. Then it is written that you have taken loan of rupees 5 lakhs from my client. Okay. As you can check here, it is written as LONE. Okay. And after it is written 5 lakhs from my client, and on the basis of my client, you had issued a check. That is also wrong. Bearing number this, dated this, which was not honored by the bank in which the same was deposited in the branch. Then there is a formatting issue, that it is evident that there is no formatting, there is no spacing between. That will show to the other party that you have no experience in the legal field. Okay, they will not be bothering to reply you even. Okay, send this check. Here the check spelling are good. Okay, then it is written as for amount 5 lakh with a view. So you can, my purpose of showing you this legal notice is that 90% of the lawyers in India are sending these type of legal notice, which has no backing in the mind of that other party. They will not bother you to reply even for this type of legal notice. And this person has like wind up this legal notice within 1 page. How will you get that matter? There is no context of the case. There are no facts of the case. There are no general understanding that if you are not following this thing, that we will there is jurisdiction of this, there is a jurisdiction of this particular case. There is nothing in like that. So these type of legal notices are being sent by the lawyers in India. So basically, my purpose to show you.
Sir, I have one doubt.
Yeah, please ask.
Sir, does legal notice has any bearing from the court like stamps or
No.
affidavit type paper?
Like, you are a lawyer, you are authorized by bar councils to send the legal notice, and you can send it in your backing, and it is admissible in any court. You can just mark your stamp in that. Okay, after you will be enrolled as a lawyer, you will be given a particular number. Like in Delhi, it started with D. Okay, D/1234/ the year in which you will be enrolling. Like if anyone has enrolled in 2025, it will be like D/2345/2025. It will be your enrollment number with the Bar Council of Delhi. That will be with you for whole of your life. Okay, it will
Okay,
be.
sir. Thank you.
Yeah, you can just make a stamp of that enrollment number, and you can just add that in this legal notice. Okay, and like we should skip do. So this legal notice is generally, this is the all the things like as a testament to her exceptional. My client was promoted. After that, when she was hired, then she was promoted as a vice president of the company. Okay, so these are the general facts of this particular legal notice. Okay, so after you are done with your facts of the case, okay, then there comes your legal terminologies, that if you are not following our legal notice, then you will be liable for this. Okay, these are the general facts. Like if it will be depending on case to case basis, that I am suffering this, our client has suffered this, our client has suffered that. Okay, so these are the general things that you have to keep in mind. No, so now I will be skipping to the legal part. So if you will check that my legal notice is of 11 pages. Okay, there is no bar. You can send your legal notice in one page also if your content is so small. But it is prescribed if you are sending a legal notice, because it will show how your legal experience is, how much you are qualified in your this legal field, and it will have a much effect on the other party if you will send it like professionally. Okay, so it is suggested, do not skip the main things, do not skip the facts of the case, do not skip any of the issue, because if you will skip anything, they will make a issue of that, the other party will make a issue of that, they will send you the reply of that legal notice that we are not liable, this is not mentioned in your legal notice, this is not mentioned, then you have to unnecessarily you have to send a reply again to that party. Once you have sent them a legal notice, they will reply you, then you have to send them a counter reply also. Okay, so to avoid that, you should go with the good legal notice with all the facts of the case, with all the legal terminologies of the case, with all the legal consequences of the case. That if we are going to the court, we will do this thing, and you have to face this much consequences. Yeah, as you can see this, like our facts have already, we are done with our facts of the case. Yeah, so I will give you a context at the last. So it is written that on April 22, 2025, the company formally terminated my client employment through a leaving letter. Okay, so our client was terminated by the other party. Okay, uh, after she has completed his maternity period, that is of 180 days after the application that she has given in the company. Okay, after that very day, she has completed her like maternity period on 20th of April, and she was terminated on 22nd of April, and she was not given her rightful salary also. Like her salary due was above 10 lakh rupees, but she was given only 4 lakhs. So her outstanding money was around 6 lakhs to 7 lakhs. 6 lakh was his her principal amount, only principal amount that she was liable. She was to the company was liable to give to our client. Okay, so it was written that the company has terminated our client on 22nd of April 2025. Okay, then it was written that this termination was effected despite my client being on protected maternity leave, because if anyone is sending a termination email to your client when she was on maternity period, then that will be constituted as a crime, and that may uh, give rise to a criminal case also on the employer. Okay, so keep this thing in mind. If like anyone of your colleague or if anyone of your like client is facing such thing, then the employer will be liable for this thing for violating the very act, maternity benefit act. Okay, yeah. So then we have written that this demand constitutes an unlawful attempt to reclaim rightfully earned incentive, because there was an incentive that was given by the company to our client, that was a laptop and a mobile that was given, and the company was demanding it back in lieu of the salary. They were saying that we will give you the salary only once that you have submitted your laptop and mobile phone that was given by the company, but that was given by the company for as an incentive. So we have rebuted that thing, because earlier to this, the client, our client and the company has some communications also. Okay, so as per that communication, we have to rebut that communications also. We have to give counter reply for that communication that was earlier happened. So between our client and the other party, there was a communication that you should submit your laptop and the mobile. But since our client has informed us that the very mobile and the laptop was given as an incentive to me for my performance. Okay, so we have rebuted that point that this demand constitutes an unlawful attempt to reclaim rightfully earned incentives, because it was given as an incentive, and if the company is claiming that that was a wrongful claim by the company, so we have rebutted that claim that my client is not liable to give that uh, mobile and that laptop back. Okay, yeah. Then after this thing, we are skipping on to the part of the, like we have particularly mentioned this thing based on the facts we have given above. Your company has committed the following violations of law. Company has violated the very maternity benefit act, and we have specifically written the sections also. It will give a huge impact on the other party. It will make a huge impact on the other party, that you have knowledge of law, that you have knowledge of the very act which they have violated. So I have given that, my team has given that specifically, that you have violated section 4, 5, 9 and 12 by attempting to terminate my client's employment during maternity leave. Okay, and after that, they have not given failure, they have failed to give the full maternity benefits. She was entitled for a maternity benefit of more than 10 lakhs, but she was given only 4 lakhs. Okay, and the principal amount of 6 lakhs was pending on the employer side. Okay, and after that, we have written this thing, we have mentioned this thing, wrongful termination evidenced by termination letter. We have written it out that the termination letter was sent on 22nd April 2025. Okay, okay, then we have written that you have breached the employment contract also, so it will be counted as contract act violation also. Breach of by failing to honor the terms of the employment and payment obligation as per the appointment letter dated 23rd of September 2022. So if you will check, we have written each and everything. We have written like most of the smaller things also, that our client was appointed by on this date. Our client was given mobile phone on this date. Our client was given mobile as an incentive. We have written each and everything, so that there is a 0% chance that the other party will claim something other than this. So you should do this. Okay. So we have written the other things also, that failure to honor the terms of promoting and corresponding outlined as mentioned in the promotion letter dated 10th May of 2024. And then after you are done with this thing, there is a general prescribed line. All of the lawyers in India usually use this line, that your course of actions, your actions have caused our client a mental harassment. And this is the other thing, because it is applicable only on this case, that pressure exerted during maternity leave. You can just skip to this part, that your actions have caused a huge mental harassment to our client, and we are claiming this particular amount. As of now, I am giving just the context of this case. And after that, we have given the monetary things, like we are demanding this. Firstly, we have given the violations, that your company has violated this, your company has violated that. And after that, we have given our demands, that what we are demanding through this legal notice, because generally legal notice is the demanding notice. It is generally treated as a demand notice, that you are demanding something from the other side. Okay. So what our demands are, we have to write that down very concisely, very properly. So it is written here that my client hereby demands that within 15 days. This is generally the prescribed time that you have to give to the other party. Okay. Generally, some lawyers are of view that we should give only 7 days of time. Some give 30 days of time. Some give 10 days of time. But as per my view, you should give at least 15 working days to the other party, so that they can reply within that period. And if they are not replying within 15 days, then you can just wait for 2 to 3 days more. In total, you can wait for 20 days also. And after that, you should send them a reminder that we are sending you the reminder for the legal notice that we have sent you on the earlier date. So if you are not responding to our reminder within 7 days, then we will be suing you in court. Like, we will file a court case against you. Okay. So if you will see right now, there is written that pay the full outstanding salary dues amounting to 7,50,000. Like, her dues was around 7,50,000 without any deductions, because the other company was claiming that there are some deductions also as per the act. But we have said that there are no deductions, because our client was rightfully claiming this thing. Okay. Just wait a second. I am sharing something with you guys in the, like, we will draft a legal notice again of this. I will share this thing. I am sharing a draft with you so that we can draft. You can read this summary of the case. Yeah, I have sent a summary of a case that we will be drafting after this journal formatting that I have taught you. We will draft that legal notice with the help of AI. Okay. So then we have write it down that pay the approved maternity insurance reimbursement of. It is written in that the other company has to reimburse you a particular amount of 50,000 if they have not taken insurance for you. Okay, so we have written that also, and we have written this thing also that we are entitled to get interest of 18%. This is the general interest that is prescribed by the court, 18% per annum. Okay, so if anyone is claiming I want interest of 50% per annum, 20% per annum, 25% per annum, they all are just vague statement. You can claim that, but the court will not allow that. Generally, usually court allow 10 to 18% per annum as an interest, depending upon case to case. Okay. Then we have written that pay the full severance package. If I will tell you, severance is a term that is used during employer-employee relationship when you are terminated without any notice by the employer. Then there is a this is the terminology that is used in the contract, that if we are terminating you without any legal notice, then you will be that then the employer will be liable for paying the severance. Okay, usually it is 2 months, usually it is 1 month or 2 months of the basic pay of the employee. So we have written that pay the full severance package as per the terms of the contract, okay, which amounts to 3 months basic salary, because it according to the contract of our client it was 3 months basic salary. Okay, and then we have written it down, we have given properly that this severance is calculated as per clause 4 of exhibit B, terms and conditions of the employment of the letter, that employment letter is that it was given by the employer. Okay, so it shows that how much we have researched on our client's case, because we have written down all things of the client, that the we have already shown that this severance is calculated as per the clause 4 of the exhibit B. Okay, there are many exhibits in the uh, employment letter, appointment letter that is given by the employer. So we have particularly written also that we are marking to the exhibit B, terms and conditions of the employment, and we have written down date also for their context, that they can check this thing also. Yeah, which is generally exhibit meaning attachments, like there are few attachments. This is the legal terminology that is used in the courts. Okay, and after that,
Okay, sir.
yeah, after that you will see that we have written that issue a proper leaving letter, because if you are dealing with any employer-employee relationship case, then there is a thing, proper leaving letter, that should be given by the employer to the employee, because after there is a uh, issue between the employer and employee, there is a high chance that they will not give you a proper leaving letter, that will affect your future course of employment, because any company that will hire you, they will have a proper background check. Okay, and if you are not having your proper leaving letter, and the other company, your past employer, will not give you a proper background check, then there might be chances that you will not be hired in any of the future employments. So we are demanding here that issue a proper leaving letter without any prejudice. Like it is written, because there are they give a leaving letter, but they usually write that thing, that the performance of the employee was not as per mark. So that was our purpose, that they should not write that. Okay, yeah. So then we have written it down that withdraw in writing any instruction or communication that prevents my client from using recommendation letter. You And then we have asked for apology for the treatment our client has faced. These are the usual things. Generally, these things are skipped by the employer also. So this is the just to write for the sake of writing, for the sake of client. We are writing this, that issue an unconditional apology or something like that. So this is the thing. So then at the end we have asked pay compensation of rupees 10 lakhs for the mental agony, harassment, generally this is not given by the courts. Usually courts allow 50,000, maximum 1 lakh, 20,000, 30,000 as a mental harassment. But in most of the cases, in 90% of the cases, this amount is not being given by any of the courts in India. This thing is being like, I have dealt with some cases in foreign courts also with my colleagues in USA, UK, and Australia. So these things are very huge in that countries. Even they used to claim 10 lakh dollars, 1 lakh dollar, $10,000, $20,000. So and the mostly in 90% of the cases, the foreign courts used to allow these mental harassment charges that we are claiming in our legal notices. And if we are filing a case with the court, then they are very strict on these issues, on mental harassment issues. As you can see that there is a huge difference between these issues between India and the other foreign countries, because they are so careful about these mental harassment and mental and discrimination issues and these type of issues. Okay, then we have simply we are winding up this. So it is written, take notice that if you fail to comply with the above demands within stipulated time of 15 days, my client will constrain to initiate. So we have written it down that what we will be doing. Filing a complaint before the labor court. Since our client has already initiated a complaint, we have written it initiated. Okay. So we have written that our client will be initiating a complaint before the labor commissioner if you fail to reply to this legal notice. Then we have written all that we will file a case of recovery for the dues. Okay. Then we have written that we will file a complaint sorry, before the National Commission for Women, because usually the National Commission for Women takes up cases in which there is a major discrimination of the laws yeah, by the employer, and they have done a very good work in our case also. National Commission for Women usually take these cases very seriously. Okay, and this is the usual course. Then at the end, as a journal formatting, we have written it down that this notice is issued without prejudice to any other legal rights. Prejudice means that we are not relinquishing our rights. We are not giving up our all the rights. It is not the case that if we are writing in this legal notice that we are claiming this, we are not saying this that we are not claiming other things. If in the near future there is anything that we have to claim and we have skipped that thing in our legal notice, then we can claim that this is that this is issued without any prejudice into any other legal rights, remedies, or entitlements available to my client, because there are n number of entitlements or legal remedies that are available to your client. We may skip that. We are a human being. There may be a error by our team. There may be a issue with our team that they have skipped that very important legal remedy. So usually we write this down that this is being issued without any prejudice to any of the legal rights of our client. Okay. So after that, it is written a copy of this legal notice is retained in my office for records. This line is written because if our case will be going before the honorable court, then you will have to produce the copy of this legal notice that is with you before the honorable court. Okay, so that's why this line is written. And after that, we have written that we have tried our level best. Our client has tried. We have done bona fide attempts to amicably resolve this issue. If you will go through this term amicably, means we are ready to settle this matter uh, by the participation of both the parties. Okay. And then usually this is the thing that my signatures are there, digital signatures are there. And after that, this is my name and the other designations. So is there any doubt with the formatting of the legal notice? And if you have any doubt, then you can ask. Then we will be skipping to the AI part. So can we skip, if you don't have any doubt, can we skip to the other part?
Sir, can you
Sir,
share the
I
copy of
have one
this?
doubt.
Yeah.
Can you share the copy of this, what you displayed?
Yeah, I will share that. No worries.
Thank you.
Yeah.
Sir, I have a doubt.
You should ask, please ask.
Sir, I have seen that in the footnotes area, there was one address written. So what address was that?
Yeah,
And
that was my address. If you can see that, that is my address only.
your office address or
Yeah, this is
for
just to make it look more better. This is not compulsory. It is just to make it more attractive, more professional. Okay, so this is my office address, LB910 Goyal Southern Heavy Road. Okay, and then it is written my email ID and phone number. Okay.
okay, got it, sir.
Yeah.
So for the purpose of internship, are we supposed to write that?
For the purpose of internship? No, no, no. You can
Like
skip this
for
thing. You can skip it.
completing the
Or
task?
if you are considering to write this part also, you can write your home address. You can, and you can type any random address also. You give your college address. Okay, that's for your purpose
O-
only. Because for the sake of internship, you can write anything. This is not a part of internship. This is a different session where I am telling you that when you will be lawyer, then what you are supposed to do. Okay, because generally there are many students that we want to go in the criminal law, we want to go in the corporate law, we want to go in the litigation. The first and the foremost thing that you will get to know is the legal notice only. From the very first of the day of the litigation, you will get numerous number of calls from your friends, from your relatives, from your clients, that please send a legal notice to this party, please send a legal notice to that party. So if you are drafting a legal notice like this, then there will be a huge impact on the other party. And if you want to draft a legal notice uh, improperly, like the other guy has done, I have already shown you that legal notice, then I can vouch on that it will have a zero impact on the other party, and it will have a zero impact on in the court also. Because since you guys will be practicing in honorable courts of the country, in high court of the country, in supreme court of the country, these things will go with you. These small things, these small, because if you are looking on the very small things of the case, then you will be then your litigation will be more and more powerful in the near future. Because if you are just keeping the necessary things in your case, then it will have a huge impact on your career. Okay, so I have,
Okay,
Sir, I
thank you.
have
yeah, please ask.
Sir, I have two questions. First one, how courts decide compensation relating to matter like harassment and agony? Second question will be, is maternity benefit only given to the period of pregnancy or after that also?
It is given during pregnancy also and post, but it is given only for 6 months, as far as my knowledge, because we have a team, dedicated team for this thing. Because I have not, I have just drafted this legal notice. There is a team that is working on these issues. As far as I know, it is a 6 months period that you can take after a certain period.
Okay, sir.
Okay.
Is it available to both or only female?
It is available to only females.
Okay, sir.
There are some companies in India right now, like many of my friends are working in TCS and other companies also, where as per the policy of the company, it is given as a paternal, to both the parents. It is given like 1 to 2 months of the leave. If you are having a child, if you are in the near future, if you are expecting a child, then you will be given, both husband and wife are given the holiday. Okay, paid
Okay,
leave,
sir.
paid leave by the company. And the earlier question you have asked, that how the courts are deciding on this part, these things are too vague, because we are just here to write it down that we are claiming 10 lakhs of the mental harassment, because it is not written anywhere that the courts will allow this. It is based on the judge, based on the circumstances of the case, like in some cases you are being harassed so much that the courts allow huge amount of mental harassment compensation. But in some cases, like this case, you are just unemployed for a month and you are claiming 10 lakh of money. So in these cases, the court will not allow more than 10,000. And if they will 10 on the, and 10,000 is the maximum as per my view. Okay.
Okay, sir. Thank
So I have shared with you this case study. So if you will see that, I have shared the summary of facts here. Okay. So this is parties involved. Yeah. You can ask your question, Ansharna.
So I wanted to ask about the legal notices. Suppose I applied for the possession of a flat in certain property and I have not been given the possession of that particular flat or the apartment. So how is the procedure of the legal notice in that case, and how it does it proceed?
Yeah, just do it with like pick up some of the legal applications of the RERA. Okay, the applicable laws of the RERA and the other laws of the state there, because these laws, the possession of the flat, the possession of these type of things generally fall under the state list. Okay, so you have to check upon that in which state that the flat is. So you have to check the local laws of the state, and then you have to check the RERA. And yeah, just you can just go through the facts of the case, just write the
So
facts.
will it attach? Do we have to attach certain evidences along with the legal notice that we have to send, or without
So
that as well?
it, if you want to, then you can annex that. It is generally written as annexures. Okay, if you want to annex that, you can annex. It will be good also. If you don't want to attach, then it will not have any issue. You can, if they are abiding to the legal notice, they are giving you the possession after your legal notice, then it is good. And if they are not doing that, then just annex that with the case when you will be going to the court. Generally, as per my view, I do not prefer to attach annexures in the legal notices because the other party is already knowing that thing. Because we are sending the legal notice to the uh, uh, that accused only. The accused is already knowing the things. Okay, so there is no issue in attaching the annexure, so you can skip that part.
Okay, sir. So also, what if in a case where I want to send a legal notice to a certain person who has breached the contract, but there is no as such contract, like there's no legal foundation there present formally, but informally the person is aware that he is bound to do a certain duty towards me, or like providing a certain service. Like, for example, there are third party organizations, or what are they called? The ones who provide maids or certain
Any
people to provide
so
certain
is there any
services.
so is there any communication between you and the other party through WhatsApp?
Yes, sir. Yes, sir. Evidences as well.
So
But
yeah,
I don't know.
you can do one thing. You can do one thing. You can just mention in the facts of the case that we have reached an agreement impliedly. We have not written that agreement explicitly. We have done the agreement impliedly, and I have all the WhatsApp chats, emails, and all the other proofs with me. Okay, so that I can produce before the honorable court when I have to. Okay, so you can do that. Generally, in a legal notice, if you are legally entitled, and if you are not legally entitled, the thing is with you that you can how you can screw the law, how you can find a loophole in the law. Okay, so you can do that thing that we have reached an agreement impliedly, and as per the agreement, you have to follow these particular things. And since you have not followed that, I'm sending you this legal notice for this particular amount, and I have all the evidences that I will attach in the court.
And what are the chances that this thing will go further and in our favor if
Yeah,
we go?
yeah, it can go in our favor if you have, if there is no contract, but if you have a general understanding over the mails, over the informal WhatsApp chats, over anything, then there is a chances. I can't say that there are 100% chances, but there are more than 50% chances in that case that you can go through that case, that you can win that case.
Okay, sir. Thank you so
And
much.
every time you are contracting with any party without any legal contract, just keep in mind, if you are having any chats, any emails with that party, just delete their number. Firstly, delete their number, not chats. Delete their number and then take screenshots of the case, because in many cases it is seen like you supposedly you are ABCD and you are chatting with me, Mani Goyal, and you are sending me some things that sir, please draft this legal notice, I will pay you 5,000 and some like thing, and then you have taken the screenshots that I will be giving Manik sir rupees 5,000, but it will be showing Manik sir. Okay, it will not be displaying my number, my contact in the screenshots. So it is necessary to produce in the code that it will showing my number only, because
Okay, sir.
you can save anyone's number as Manik. Okay, but
Yes, sir.
if it is displaying your contact, you can't bypass that. There are chances you can bypass that also, but there are 99 to 90 to 99% chances that the code will admit that thing in the code.
Sir, in this era of AI time, we can edit number, no?
Yeah, uh, that is with the course. We need not to worry about that. If we are like with any other party, if we are also generating the AI images and producing before the gate, that is for the code. We need not to worry about that. Okay. Earlier also there are many tools, Adobe Photoshop and other things like that, that you can Photoshop anything, you can do anything, but these things will be taken care by the code. Like, so you can see my screen. I have given you the, so I think all of you are added in the WhatsApp group, na? Is there anyone who is not available in the WhatsApp group? If you can read this document in the 5 minutes, we will take a 5 minutes break. If you can read this document, then I will be giving you the contest. After that, we will be drafting this legal notice with the help of AI. Okay. And if someone has any doubt in that break of 5 minutes, then you can ask them. At 10:10, we will resume our class. In the meantime, you can read that document.
Thôi cái bút lục. अच्छा.
So can you all confirm that you have read that document?
Yes, sir.
So can you confirm? Can you all confirm in the chat that you all have read that? So, okay, I will be resuming this class. So as you can see that I am sharing this document, and I have copied all the summary of this case, all the facts of this case. Okay, and after that we will use okay. So as you can see this screen that I am using the software, AI software named as Cloud, CLAUDE. You can write it down, or I will give you in chat. Just a second. Okay. So the name of this AI website is cloud.ai. Okay. So it is much better than ChatGPT. If you will use ChatGPT for your legal purposes, then you may be in a big trouble. Okay. Because generally it is seen in all the courts of India that there are many lawyers who are blindly using AI. I will not say that you should use AI blindly, that you are just giving the commands to the AI that draft a case for me, draft a this for me, draft that of me, because there are many AI softwares as of now that can draft a good SLPs also in Supreme Court of India. Many of my juniors, many of my colleagues, even me, use many software, Jurisphere and the other softwares for the purposes of SLP drafting also. But that doesn't mean that you will skip the basic parts of that. If you are giving them proper facts, proper data, proper case laws, because there is a uh, huge issue in the courts that the lawyers who are using ChatGPT, the ChatGPT is generating cases on their own. Like there is no case between Manik versus any XYZ, but ChatGPT will give you a case between Manik versus XYZ. And when you will check the citation of that case, okay, and when you will put that in SAC online, Manupatra, and any other search engine, then it will show you that no such case existed ever. But the ChatGPT will give you the case as it's, and you will be shocked that ChatGPT has given that, and it will give you the all the details of that case that never existed. Okay, so you will be in big trouble in the court, and this thing is being recorded in the Supreme Court judgment also, that there was some guy there was some lawyer who has used ChatGPT, and the bench was of Justice B.R. Gawai, the Honorable Chief Justice of India right now. So that guy have used ChatGPT, and that the ChatGPT as usual have generated imaginary cases. And when the registry has checked that cases, that citations, and all that things, they go to know that no such cases existed ever. So the court taken note of that, and they have asked the lawyer that you should file a proper application with the court again, and no lawyer will do such things in the court. We will file a contempt of court action against you. Okay, so keep these things in mind when you are using AI. As of now, I will say the free version of cloud of this AI that I'm teaching you, this is much better than ChatGPT, much better than Gemini Pro, much better than any of the other free available versions. Okay, since Jurisphere is paid, since all other legal AIs are paid. Okay, so I will not ask you to take the subscription of that, because that is you have to pay huge money, around 10 to 12,000, 15,000, 20,000 also for the legal AIs. But this AI is good enough to start with. since you all have read the summary that I have given you,
Sir, I have a question, sir.
just wait a second. I have attached all the facts of the case. I have attached all the things in that summary that I have given you. When you are going through a case, you just need to take out the facts of the case. Like if you are going through any case, you should take out the facts, important names of the persons, credit, like any of the parties, defendant party, accused party, or any other things. Okay, so when you are good to go with the uh, summary of the case, when you are confident enough that you have extracted each and everything from this case, then you can just do one thing. You can just do one thing, like draft a legal notice on the facts given below, and just write it down. That don't make it too short, keep it bit large and legal. Okay, then you can just paste the legal summary of that case. Okay, and even I have that copy of the summary. Then you can you also can attach the file also. There is an option of upload a file. Okay, you can upload also. Okay, after that you just click on that and it will start generating a legal notice for you. And you can do this at your part also. If you are using your laptop or mobile phone or any other uh, hardware with you, you can do this exercise at your end also, because I have drafted that very summary for you guys only, that you can draft that. Since I am showing you that how to draft it, that you can change the context of the case, since there are many people who were asking about that flat thing also and the other things also. You can take a imaginary, you can draft a imaginary legal notice also. Okay, you can check that this AI is still drafting, because we have given, you have to given a proper prompt. Since these things are when you are giving command to the AI, that is known as prompt. You should be giving them a proper prompt, that make it large, make it small, give a proper understanding to this case, or which, yeah, as you can see, it is still in progress.
Sir, can you please repeat the prompt as I have to mention that prompt in my diary?
It's small, that you can mention that draft a legal notice. I will show you that
Okay.
now. Just a second.
Yeah.
Yeah, that I have write this down. That draft a legal notice on the facts given below, but you should be specific about the summary that you are extracting from your case. Like if anyone is contacting you regarding their case, that's ma'am, I have a case that I have given someone rupees 2 lakhs, and now I am claiming that back. The other party is not giving that. So you should take the name of your party, your client, other client, in on which date they have given that amount to the other party, and when they have sent the uh, that thing communication to the other party claiming the amount back. So you should be particular about these things. Okay, since this is the legal document is ready, so we will check this. Just wait a second. Let me remove this thing from the screen.
Sir, this AI tool is free or paid?
This
Sir?
AI tool is free.
Oh, okay, sir. Thank you.
Yeah. So since you can see this, that we have written this thing, it is showing legal notice under section 138. Just wait a second. Just skip this part. This is not under 138. May be written in the summary of the case. Just wait a second. Because 138 is applicable only when you have made a payment through checks or any of the negotiable instruments. 138 cannot be applicable in every case. If you have given any money through your bank account, through your any other mode, then it will not be counted as a legal notice or a case under 138. Okay. It will be a recovery case. It can be under CPC. It can be under any other thing, but it cannot be under 138. Okay. So this is the date that I have already told you the formatting of that case to the managing director of the company.
Sorry to interject, sir. Could you please repeat what you said recently?
Yeah, I have told you that if you are sending a legal notice to the other party, you should be more careful about that thing. That not every recovery case is of section 138. Since it's written here that section 138, it may be a issue with my summary or the team has written it out somewhere of 138. Yeah, no. So section 138 is applicable only then if you have given a check to the other party and the other party has not honored that. Okay. And if you have given that the other party directly amount to the, since this is the generation of UPI, like you have given a money to your friend of 50,000 and he's not giving it back, you can't say that I will be suing you in under section 138. Then you have other remedies of recovery. So that's my whole purpose of saying here.
All right, sir.
Yeah. So as you can see here, it is written subject. Okay, and in subject we have written it down: legal notice for recovery of outstanding dues amounting to 1 crore 52 lakhs 86,786 rupees 21 paisa. Okay, we have written it down properly. That AI have written it properly that we are claiming this amount along with interest and other costs. Okay, so this is what the chat GPT has drafted. So after this, just skip this part through because this is written here because we have not enshrined this thing on the top of the legal notice. You have to write it on the top of the legal notice with your name, Advocate, Supreme Court of India, your address, your email, your contact number. Okay, and you can skip this also on behalf of. You can do this thing. You can just write it down here also. But I am just telling you on my behalf as what I used to draft, what I have drafted in the legal notices because it looks more professional. So if you want to, you can just go through this also. You can write it down as like this also. Okay. Then the main part came notice under instruction, and I will tell you that you can try this with chat GPT also. If you will give the same prompt same summary to the chat GPT, you will get to know the difference between these both AIs. There will be a huge difference between both the AI models. Okay, then as usual, it is written under instructions from and on behalf of my client. This, and check here, it is written as herein refer to as my client or the creator. I, Rajesh Kumar Sharma. You can skip this also if you don't want to. You can write it also. Do hereby serve you upon this legal notice. There are written the sections of the case and calling you to take notice of the contents. Basically, as per the summary of this case, our client has given services to the other party and they have raised some invoices with the other party, but the other party has not given the amount to our client. They have not honored the invoices. Okay, so this case is of the recovery of our money. Okay, because since we have proof as our invoices, we have mails as communication that we are claiming our amount. Okay, so there is a dispute between both the parties. So if you want to, these are called as the subheadings. Okay, if you want to write it down, then you can write it down, because in half of the legal notices I used to write this, and in half of the cases I generally do not, because I have already shown you that other case. I have not used this. Okay, so you can use this also, introduction and parties, because it will make easy for the other party to get through the context of the case, that where the introduction is written, where the legal consequences are given. Okay, or if you want to delete it, then just copy this whole copy it from here. Okay, and paste it in Word and just delete this part. Okay, and make it 1 2 3 4 5 6 7 8. Here the facts of the case are given. My client taxpayer is a company duly, the whole facts of the case. Okay, then it is written, your good self A is also a company. We have given the context of the other party to other party itself, that your company is registered and when it is registered and where it is addresses. Okay, so then we have given the background of the contract, that we have that on or about June 15 2022, there may be fewer things that you have to check on, that you have to go through properly through this uh, legal notice that is generated by the AI.
Sir, can you show your fact of case, what you have written in AI, so that can convert into legal notice?
Yeah, what you just said?
सर क्या आप फैक्ट ऑफ केस दिखा सकते हैं अपना, जो लीगल नोटिस में एआई कन्वर्ट
Facts of
किया
the
है?
case, facts of the
हाँ
case
हाँ
I have already given in the group chat. You are not there. If you will check in the group, I have already given the facts of the case there. Nevertheless, I have shared that also there. I have just copied the facts here, summary of the facts, the name of the parties, and all the other information regarding the contract, on which date the contract is entered, on which date the contract is violated, and I have given the invoice details also. I have given the invoice details with the invoice number also, that the invoice is generated on this particular date, the invoice is generated on that particular date, and the last invoice has been generated on this particular date, and the total,
yes sir
yeah, and the total outstanding amount is 1 crore 14 lakh 70,051 rupees 21 paisa. And then I have written that according to the legal interest, that is 18%, we have calculated this interest as 37 lakhs 41,735 rupees. So if you will add that, we have written that amount in the subject of the legal notice. Okay. So here the AI is giving the background of the legal notice. Okay. And these are the legal, these are the background of the case are given, that we have entered into the contract on June 15, and see how briefly they are giving the facts. They have written it in bold letter, date, manpower contract agreement, the agreement, and these are the clauses of the, if you will see here it is written the clause of the agreement, that scope of services, service delivery standards, payment terms, all the details are given in the background. Okay, and then we have written that we have performed all the contractual obligations. Okay, these are all the facts. If you will draft it, you can do one thing, you can draft it at your end, you can send it on our WhatsApp. Our team will check that. I can't make sure that all the legal notices will be checked, but I will make sure that I will ask my team to check all the legal notices. Okay, but it may take time. You can draft it at your end and you can send it to us, and we will check that what are the improvements, or if you have drafted it good with the, but use AI, because the main purpose of this class is to make sure, because it will cut your time by 1/10. That if you are taking around 2 hours, 3 hours, 4 hours to draft a legal notice, AI can do that thing within 10 to 15 minutes or maximum 20 minutes. That is the highest amount of time that AI can take. Okay, then these are all the context of the background that we have given, that we have done our best in the service delivery, that we have given our services within time. Okay, and then we have written that you have breach of contract, because since there is a breach of contract, because in the very contract we have written that you have to give timely payments to the other party, to our client, but since you are not honoring the invoices, then you are doing the breach of the contract. Okay, then we have given a table where all the invoices, amounts, dates, due dates, and interest is given. And after that, if you will see that we have given the context, and whenever you are sending a legal notice to the other party, you should claim your legal fees from the other party also. You need not to take that from the other party, but you should mention that a legal notice fees of rupees this should be paid by you. All the legal expenses would be borne by the defendant, would be borne by the your party. Yeah. Then we have written it down that we have tried our level best to seek a amicable settlement. Since I have already told you that amicable settlement is the settlement between parties before going to the court. Okay, that it is written here that my client, acting in good faith with a genuine desire to maintain cordial business relations and resolve the dispute amicably without that they have given you multiple communications on your email and other things, but since you are not honoring that, we have no other option than legal notice. And if you will not reply to this legal notice also, then we will be going to the court. That's the only option we are left with. And then we have written that consequences. Yeah, this is the general consequences that you will be liable for this thing. Because if the amount is more than 1 crore, the other company, if registered under company, that the other company is liable under insolvency and bankruptcy code also. Okay, so we have given that also, that the persistent non-payment, despite thereby attracting the provisions of insolvency and bankruptcy code also. But in insolvency and bankruptcy code, if you are well aware, if you are not aware also, then I will tell you that in insolvency and bankruptcy code, after this legal notice, you will have to issue a demand notice also, as per the section 8 of the insolvency and bankruptcy code. Okay, that's a different demand notice that is prescribed by the NCLT, National Company Law Tribunal. Okay, so you have to follow that also. You can't say that we have already issued the legal notice. That's a different legal notice. And after this thing, you can just, yeah, there is a legal demands, our legal demand that I have already showed you in the previous notice also, that we should demand the things from them, that we are demanding this thing Yeah. And at the end, we have consequences of non-compliance that I have showed you in the earlier legal notice also, that take further notice that if you fail to reply in 15 days, this is the standard time that is given to the other parties, 15 days. Civil suit for recovery, that is the most appropriate legal remedy in our case. Then insolvency proceedings, since insolvency proceedings are fast, it is prescribed. Criminal proceedings like breach of criminal trust and fraud and other legal provisions. Okay. And all the other, we are claiming all the other costs that will be applicable in this case, lawyers' fees, any other court fees will be borne by the other party when we will be winning the case. Yeah, we have given a proper jurisdiction in this case also. That is not important as such in legal notices. It is important in drafting the legal cases, but in legal notices it is not as much as that important that you need not to give the jurisdiction. But since it's given here, you can mention that also, that that all disputes around legal notice will be exclusively jurisdiction iski hai Gurgaon, Haryana. Okay, since the companies are based there. So just wait a second. I am trying one thing more. I will show you that. Just wait a second. Yeah, if you will see that I have given the prompt to the AI that remove the subheadings. As you will, as you have already seen that I have given the prompt earlier, where the AI has generated subheadings, that background and these things. So